Court calls the case People versus Byron Blair.
Professional honor for the people.
Before this courtroom even settles into rhythm, we're watching a defendant step up to plead guilty to retail fraud in the second degree. A misdemeanor that carries up to 1 year in jail, serious fines, and a ripple effect that can follow someone far beyond today. Judge Simpson, calm but razor sharp, is about to walk Mr. Byron Blair through a plea that will dismiss a more serious first-degree retail fraud charge. That's not small. That's strategic. But this isn't just about shoplifting. This is about probation status, prior cases, bench warrants, medical issues, bond arguments, and a defendant who is equal parts nervous and unexpectedly charismatic. In just minutes, we're going to see humor collide with real legal consequences and a judge who balances levity with firm authority. Watch closely, because when Mr. Blair hears he won't be sentenced by Judge Simpson, but by Judge Valvo, his reaction turns this plea into one of the most human courtroom moments you'll see. And behind the laughs, very real stakes, very real consequences. Let's step into it.
Your Honor, Alexis Plume, I am appearing with and on behalf of Mr. Blair, who is approaching. And Mr. Blair, could you state your full name?
Byron James Blair.
All right. I have before me a plea form. Indicates he would be pleading guilty to the charge of retail fraud, second degree, the 1 year offense. Upon a successful plea to that charge, count one, retail fraud in the first, would be dismissed.
Yes, that is correct, Your Honor. I have gone over that offer with him as well as an advice of rights, which should be in the file as well.
All right, very good. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Byron Blair.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of retail fraud in the second degree.
Yes.
That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that, sir?
Okay.
Okay. Understanding all of that, do you still wish to plead guilty?
Yes.
Are you sure that's what you want to do?
Yeah. You scared me. Like, who was Valvo? Like? I'm sorry. You like, are you sure?
Like, who is Valvo?
Talked about the
Oh, she's the
judge
chief
in
judge of the 15th
15th
District Court.
in downtown Ann Arbor. So remember, Judge Simpson is not going to sentence you.
Oh,
You're gonna be
I
sentenced
got you. I got you. I got you. I got you.
Okay, what do you got me for? What are you telling me?
No, I understand what you were saying. Like, the way you said it was like I was just imagining the executioner or something. Like.
This moment right here changes the energy of the courtroom. What starts as a routine advisement suddenly becomes comedic relief. But there's something deeper going on. When a defendant hears, "You won't be sentenced by me," anxiety spikes. That reaction, imagining an executioner, might sound dramatic, but psychologically, it reveals how intimidating sentencing can feel. Legally, Judge Simpson is required to clarify that another judge, in this case, Judge Valvo, will handle sentencing. That matters because defendants must knowingly and voluntarily enter a plea, understanding exactly who will decide their fate. If there's confusion, even emotional confusion, it could undermine the validity of the plea. Notice how Judge Simpson keeps it light but quickly regains control. Humor is allowed, chaos isn't. Let me ask you this. If you were about to plead guilty and suddenly found out a different judge would decide your sentence, would that make you hesitate? Or would you move forward anyway?
Oh, I was scared for a minute. Like, who was Valvo?
Oh, so you
Like,
thought Judge Valvo was an executioner?
Yeah, like you know it's not gonna be me.
No, I'll call her today and let her know.
No.
I mean, I just to share that information.
No, sir, I'm sorry. Okay, I'm sorry.
Wow, and of all the judges, say that. All right. Okay, you're clear now. I'm just taking your plea. You would have a right to have me sentence you, but I need you to understand that this case is set not to be sentenced, that I would not do the sentencing.
Okay, I got you.
You got it?
I got
You okay with that?
Yes, I'm cool.
Okay, so understanding all of that now. Do you, do you still wish to plead guilty to the
Yes, sir.
charge?
Yes,
You
sir.
do?
Yes, sir.
All right,
Yes,
and
sir.
to the charge of retail fraud second, how do you plead?
Guilty, sir.
All right, now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, yes.
All right, you signed an advice of rights form, is that correct?
Yes, I did.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium there. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, yes.
You understand you're giving up your right to appeal of right.
Yes, I did.
Are you on probation or parole?
I just got on probation on the 11th in Detroit. Yeah.
So you're off, you're not under the jurisdiction of any court at this time.
I'm on probation. No.
He's on
No, I
probation out
just
of
took
Wayne
probation. I'm
County.
trying to get all of my stuff together. I've been on.
I don't know what that meant. Counsel?
He was not on probation or parole at the time of the
No.
offense. He has now recently been sentenced to
Thank you.
probation.
Yeah, for old case, 2020 or something.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead to this charge?
Nope.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, I am.
of your own free will. And because you believe that you're guilty of this offense?
Yes, I do.
June 1st, 2024, at the location of 303 South State Street, City of Ann Arbor, Washington County, State of Michigan. Tell this court what you did on that date involving the M-Den store that makes you believe that you're guilty of this.
I exited with some items, but they got returned back, some Jordan shirts, a couple hats or something like that.
Okay, so you went into the store.
Yeah, I exited. Yeah, I didn't pay for it.
Okay.
Here's the factual basis. This is the part many viewers overlook, but legally, it's essential. The court cannot accept a guilty plea unless there is a clear factual admission that satisfies every element of the crime. Retail fraud in the second degree requires proof that the defendant intended to steal merchandise valued between specific thresholds. Here, more than $200. Mr. Blair admits he entered the store, took merchandise, exited without paying, and lacked permission. That checks every legal box. And notice how the judge walks him through it step by step. You went in, you took property, you tried to leave without paying. That's not interrogation, it's structured confirmation. Also important, he acknowledges the value exceeded $200. That's what elevates it to second degree. If it were lower, we'd be looking at a different charge level. This is where the admission locks in the plea.
I got it. So you went into the store, you took property that
Yeah,
the store had for sale.
yes,
They were open to the public,
yes, yes.
and you tried to walk out of the store
Yes, I
without
did.
paying for that.
Yes, I did.
Is that correct?
Sir.
All right. And you didn't have anybody's permission to do that?
No, I didn't have nobody.
All right. Was the value, is this on value or prior?
Value.
All right. So was the value total of the property that you tried to take out of the store, was that in excess of $200?
Yes, it was.
All right, counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is also satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. The pre-sentence investigation and report is ordered through 15th District Court probation. Sentencing will be
It might be.
May 20th, 2025, 9 a.m. before Judge Valvo.
Okay.
Judge Valvo.
And just like that, the plea is accepted. Count 1, the more serious first-degree retail fraud charge, is dismissed. That's a tangible benefit of this deal. But here's what's coming next. A pre-sentence investigation report, or PSIR. This document is powerful. It will outline Mr. Blair's criminal history, background, employment, health issues, and recommendations for sentencing. Judges rely heavily on it. So even though today feels lighter, even humorous, the real decision hasn't happened yet. Sentencing before Judge Valvo could include probation, jail time, fines, restitution, or structured programs. This is the calm before the consequences.
Not execution.
I know.
All right.
And Your Honor,
I'm going to call her though.
may I briefly address bond?
Yeah, go ahead.
Okay. Your Honor, we're asking the court to consider a personal bond for Mr. Blair. The reason that bond is set high on this file is because there were a couple of failures to appear in the past. Mr. Blair has explained that those failures to appear were due both to him being in and out of the hospital. He does suffer with congestive heart failure. And that's one of the reasons he would like to be out of custody to continue his medical treatment, as well as going back and forth between this county and the Wayne County Jail. He has now resolved all of his cases in Wayne County. I don't see that he has any out-of-county holds. He was recently placed on probation in Wayne County, so he's a little worried about picking up violations and not getting the programming aspects of his probation completed because of being in custody here. If he was released, he would be going back to the Delanis Center to live for right now. He is participating in their Pathways program. He has a caseworker there as well as a CMH caseworker that he's been seeing in the jail. He did provide me with their contact information. And he does have a phone, so we'll be able to reach him. He just wants the court to know that he did not mean to miss his court dates, and would like the court to consider allowing a personal bond. His other cases in this county are retail frauds. They all have very low bonds set right now, just so that he was getting credit while this case was holding him. I do believe his other cases in 15th,
No,
he
no.
would get a,
Please go on.
I'm sorry, I do believe his other cases in 15th would revert to personal bonds if he was given a personal bond on this case.
Any response?
Your Honor, this is one of 5 pending cases holding the defendant right now. They're all retail fraud. Yeah, I'm concerned with, I understand he's saying he was sick, but he did have, I think, at least 3 bench warrants in this case.
Now the tone shifts dramatically. Bond arguments are where credibility matters. The defense is asking for a personal bond, essentially release without cash payment, arguing medical issues, probation compliance, housing stability, and treatment participation. But the prosecution counters with something serious: multiple failures to appear and bench warrants. Bench warrants signal to a judge that a defendant hasn't shown up when ordered. That directly impacts bond decisions because bond exists to ensure court appearance. This becomes a balancing test: medical hardship versus reliability, health concerns versus prior noncompliance. Here's the question for viewers: should past failures automatically block someone from getting a personal bond, even if they claim hospitalizations and system confusion caused it? Or does the court need strict accountability above all else? This is where judicial discretion becomes everything.
So I'm going to request that bond continue at least until the time of the PSIR.
I tried, but I was in the hospital. And then one time y'all pulled it back because y'all had me mistaken. Oh, can I talk?
You were in the hospital, you were going back and
called
forth
up here.
between Wayne County and here.
I called your office up here, and I was known that it was a mistake because y'all had me down as being in custody doing
Y'all,
Zoom.
that's me.
Not y'all, okay.
Go ahead, no, I'm listening.
The Washtenaw County court system, right?
Oh, that big y'all.
Okay, yeah, the big
Okay,
y'all.
yeah, okay, go ahead.
It was a mix. Okay. One incident, I left here. I wasn't released from custody because I was picked up by Wayne County. I was held there, didn't Zoom. So when I get out of Wayne County on tether, I had a warrant for you instantly there.
Acting Ruby, why are you nodding like all this is? No, go ahead.
Like this is crazy. I just been ping-ponging back and forth between Wayne County and Washington.
This is one of the most revealing segments of the hearing. Mr. Blair is describing what many defendants experience when they have cases in multiple counties: administrative chaos, transfers, holds, tether issues, warrants triggered automatically when someone is in custody elsewhere. It becomes a loop. Legally speaking, being in custody in another jurisdiction can sometimes excuse a failure to appear, but it has to be documented. Judges don't simply accept, "I was locked up somewhere else," without verification. The burden is still on the defendant to communicate. What's compelling here is that he's not denying responsibility. He's explaining systemic overlap. The ping-pong analogy isn't just colorful language. It reflects how fragmented county systems can create technical violations that snowball into credibility concerns. From the bench's perspective, though, repeated warrants signal risk. From the defendant's perspective, it feels procedural. That tension is exactly what bond hearings are about.
So while I was in Wayne County, they never zoomed me to come here. So when they kicked me out on tether, when I paid bond, I get out on tether, right? They say you have a warrant in Washington County. For what? For not going to court. I said, okay. I come out here to Washington County. I ended up in custody trying to figure out how to turn myself in. I come back up in here, y'all set me another court date. Now guess what happened?
That's it. Y'all.
The Washington County court.
Okay, go ahead.
Okay, now this is what happens the next time. I'm on tether. They cut my tether off because I was in here so long waiting to see you that my tether went dead. Now I got to go back to the new Wayne County jail, which is like backed up 2 to 3 weeks just to get out on tether. So by the time I get back out on tether, they had me another paper again to say you would now have another warrant in Washington County for missing court. I'm like, I'm ping-ponging back and forth. When I just got my tether off on the 11th, they called y'all Washington County.
Y'all, all of us?
They called the courts up.
Okay.
They let y'all know.
I'm just trying to
Because you gotta have a lien. You gotta have a lien when you get sentenced to probation time. So I went in prepared to come in, right? And this and that. They told me, advisor release, take care of it when you get up here. So I got up here. I got with my caseworker, this, that. I was supposed to be going to this transitional housing stuff set up, this and that. I made sure I had my house stuff set up here first. And then now I'm trying to see what you.
If I give you a PR, will you stop?
That line is pure Judge Simpson. Direct, efficient, slightly humorous, but legally pointed. A personal recognizance bond, or PR bond, means release based solely on a promise to appear. No cash, no surety, just trust. When a judge asks, "Will you stop?" it's shorthand for, "If I trust you, will you comply?" Notice how Mr. Blair answers immediately, "Yes." That moment matters. Judges evaluate demeanor, not just record. Eye contact, tone, responsiveness, all part of discretionary assessment. Bond hearings are not mini trials. They're risk assessments. Risk of flight, risk of non-appearance, risk to public safety. This is a judge testing sincerity in real time.
If you don't see me back to Detroit and ping pong me, yes. Whoever said that, yes. That's the first time I ever been able to talk.
No, I don't believe that for a minute. You are too good at talking. That would be your first time.
All right, sir.
Well, he's got other holds that are going to hold him in, but if you're asking me to reduce this bond, right now it's at 1,000 cash or surety.
No, they said that the bonds that they gave me, that it will convert into.
So he wants a personal bond on this case because that would make it a lot easier to get personal bonds on his other Washtenaw County.
Oh, I
cases.
got it. I was just ready to rule and he started talking again.
I think he did a great job.
He did. He did a fantastic
Better than
job
me.
for the last hour.
Yes, Your Honor.
That's what.
You asked me if there were other holds, and I said yes.
And
4 other cases that have.
4 other cases, that's what you were saying
Yeah.
before we.
And I'll just put the court's information to you. I see a 2019 case, 2022 case, 2023 case, and a 2024 case.
I'll grant the request to reduce his bond. They'll set his bond at $1,000 personal recognizance bond.
And there it is. The bond is reduced to personal recognizance. This is significant. Despite multiple bench warrants, despite 5 pending matters, the court extends trust. That tells you something about how Judge Simpson weighed the totality of circumstances. Medical condition, resolved cases, housing plan, probation structure. This is not leniency without thought. It's conditional trust. If Mr. Blair violates again, that trust evaporates instantly. Judicial discretion at work, measured, not reckless.
Thank you.
You're welcome.
Thank you.
Take care.
You too, sir.
And I've already sent a message to Judge Valvo. She's waiting for you. All right, take care. Bye-bye.
All right, y'all.
Court calls the case People versus Deshaun Clifton.
Your Honor. Assistant Public Defender Dr. Lee on behalf of Mr. Clifton.
That was for people?
And Your Honor, today we're going to be requesting Mr. Clifton, can you state your name?
Deshaun Clifton.
Thank you.
And Your Honor, today we're going to be requesting adjournment of the PCC in order to receive some outstanding media discovery of the dash cam and body camera. I have prepared a green sheet.
Okay, you have a green sheet?
I do.
Objection. Probable cause conference will be adjourned May 15th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Case People versus Zachary Bruno.
Richard McDuffie for the people. Assistant Public Defender Hannah Apple appearing on behalf of Mr. Bruno. Mr. Bruno, will you state your name for the record?
Zachary Bruno.
Thank you.
Your Honor, we're asking that this matter be set for a preliminary exam.
All discovery is complete.
To our knowledge, yes.
People have their witnesses available to 6. Pardon?
We will try our best.
Preliminary examination in person, May 6, 2025 at 9 a.m. before Judge Perry. Bond will continue.
Thank you.
Oh, that I passed it? I thought he was on his way. Court does call the case, People versus Antonio Cornelius.
And good morning, again, Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Cornelius, who's approaching. Can you say your name for the court?
Antonio Cornelius.
And Your Honor, we would respectfully ask for this to be set for exam.
You seem to be doing better than your last case. Okay.
We're off to
Discovery is complete.
to our knowledge, Your Honor.
All right. People have their witnesses available on the 6th. Preliminary examination in person, May 6, 2025. 9 a.m. Sorry, 12 p.m., 12 noon, before me. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Gregory Davis.
Richard McDuffie for the people.
And that is me again, Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Davis, who is approaching. Mr. Davis, could you say your name for the court?
Gregory Davis.
Thank you.
Your Honor, this has been postponed a couple times. And we were trying to see if we could consolidate it with the case that we were told is upcoming. That case has not been charged or authorized. So we are asking for an exam date at this time.
Now we transition into a different defendant, Gregory Davis. And here, the issue shifts from plea to procedural delay. The defense mentions consolidation and outstanding discovery. Specifically a 911 call. Discovery delays can impact constitutional rights. Defendants are entitled to evidence the prosecution intends to use. If critical evidence like a 911 call isn't turned over, proceeding too quickly could undermine fairness. But there's pressure here. Mr. Davis is in custody. Time matters. Every adjournment equals more days in jail. This is the constant tension in criminal courts. Move fast enough to protect liberty, but slow enough to protect due process.
In terms of discovery, I did request the 911 call back in March. We don't have it, but I don't want to keep waiting. Mr. Davis is held in jail on this, and so I can't keep adjourning it just for that.
People have their witnesses available to 6.
We will try our best, and Ms. Yagi, I thought we sent that 911 call to you a few weeks ago, so I will check on that again.
Thank you.
Preliminary examination, May 6, 2025, 9 a.m. before Judge Perry.
Your Honor, may I briefly just address bond?
Briefly.
Okay, this is one of two cases that are holding him, or he has one or two cases out of 14B. One is just traffic, one is DV. He has done over 50 some days on the DV 14B case. He was set for final settlement tomorrow, but then he was removed from the docket because they didn't know he was in jail. And somehow he had just been sitting with that outstanding warrant without being arraigned on it. He is now set to go to 14B on Monday. And obviously, I don't know what they're going to do, but I would ask if the court would consider lowering his bond. It's a 5,000 cash surety right now. I would ask for a 10% provision to be on there, because just in case they do give him a personal bond in 14B, which I'm very optimistic that they will, because he's done so much time on that case as it is. He has a job at Cracker Barrel waiting for him. And just to be candid, Your Honor, I've been representing him. This is, I think, our third PCC together. I've met with him several times. He's met with CMH in the interim. Personally, I've noticed a difference. When I first met with him, he was very loud. He was agitated. We had a really great conversation, and he actually thanked me for pointing out to him that he was so loud. He's met with CMH. He's been so genuinely reflective since. And I really mean that. I don't say that, as Your Honor knows, I don't say that about all clients. So I think he's really done a lot of reflection. And so I would ask if the court would consider a 10% provision.
Response from the people?
Your Honor, I can't speak to what 14B is going to do. Obviously, Mr. Davis's case, the issue that we have with Mr. Davis, I think, is primarily the fact that he had a case pending for exam. That case did end up being dismissed at this point because we had a witness that was not available, an officer that was going to be gone for quite some time. When one of Mr. Davis's cases was pending, we had a new incident where he showed up to that victim whose mother's house and was trying to get in. Essentially, we have the NDOB on that case. We have some bond concerns, obviously, there.
Here's where things escalate. The prosecution introduces a new alleged incident appearing at a victim's home. They also reference a separate controlled substance warrant. Bond now becomes a safety analysis. Not just appearance, but potential escalation. The prosecutor frames it as pattern behavior. The defense counters with detox, reflection, improvement. That contrast is powerful. Risk versus rehabilitation. Let me ask this. When someone appears to be improving in custody, is that growth sustainable outside jail? Or is it structure dependent? That question weighs heavily in judicial bond decisions.
The domestic violence case, I don't believe it's related to some of these other incidents. The new warrant I've heard, we do not have a response back on that further yet, but that is a completely unrelated UDAA allegation as well. Mr. Davis, should he be released? I'll leave that to the court's discretion. I do know that Mr. Davis has, I can appreciate that Mr. Davis has been improving. I think that may be because he's had a chance to essentially detox. I know that he was under the influence of apparently narcotics, I think, at the time of this incident. And Mr. Davis has a warrant out of the 35th District Court for controlled substance possession. I don't know if he is aware that that is out there. He was arraigned on that on November 10th of 2024. And that bench warrant, was issued a few weeks after that, so November of 2024. So if he were to be released, I don't know if there's a testing order on this file. We'll be requesting that, obviously, in his history. And hopefully he'll be able to get that one as well.
Your Honor, may I respond very briefly? I just have to clarify something.
Okay.
Ms. McDuffie stated he went to the victim's address. He was on house arrest there. He was supposed to be there. So this is not a case where he returned to the victim's address against the court order. He was literally on house arrest there at the address with his mom, who they're saying is the victim. But he was supposed to be there. So I just have to clarify that for the record.
Are we done?
Yes, Your Honor.
Okay, I'm going to grant your request.
Thank you.
His bond will be set at 5,000. I'll give a 10% privilege on that.
Judge Simpson grants a 10% provision. That means instead of posting the full $5,000, the defendant must post 10%, typically non-refundable, to secure release. It's a middle ground. Not full trust, not full detention. This is structured accountability. The court acknowledges improvement but keeps financial incentive attached to compliance. Balance discretion again.
Thank you.
Thank you.
Are there any no contact orders on this matter? I'm not sure what Ms. Jackie was referring to. We got a contact order with it. So
That is not true. He had a consensual contact order. We have to be clear for the record. It is not true that he had a no contact order. He was on house arrest there at his mother's address. He was allowed to have contact with her. He was
Is
supposed.
that Miss Freeman?
It is Martha Freeman, yes.
Okay, what I have is, I have a no contact with her at this time.
With this case, not with the other case.
Okay.
Thank you.
thank you for your concern.
Thank you. Okay, so
Okay. Thanks. Court calls the case, People versus London Dottery.
Very good.
Oh, boy.
Portia Feaster, First Assistant Public Defender, on behalf of Mr. London Dottery, who's approaching the podium.
Did you apologize to Ms. Constantine?
I did, Judge.
Did
She
you?
graciously forgave.
Did she accept your apology?
She said she did. I
She
pray
said
she
she
did.
did?
Yeah, she said she did.
Okay,
So I hope she really did. She said she did.
okay.
Thank you. State your name, sir.
London Battery.
Thank you.
Thank you, Judge. I have submitted a green sheet. We're requesting a 3 or 4th adjournment. We are undergoing mitigation, and I believe we're also investigating a potential motion.
How much time?
3 to 4 weeks, please.
Wow.
Whichever one is better for the court.
No. I see,
Not-
I see how you snuck.
Not picking my date, just
I know, I saw how you did that. May 20th,
thank you, Judge.
2025. 9 a.m. bond will continue.
All right.
Oh, May 20th, it's 22nd.
The 22nd.
Yes.
Thank you, Judge.
Thank you, Miss. Court calls the case of the People versus Brian Gerard.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Gerard, Your Honor. He's approaching.
Your name, sir?
Brian Gerard.
Thank you. Okay, what are we doing?
Your Honor, I've had a chance to speak with the prosecutor and speak with Mr. Gerard. He'll be waiving his exam this morning. Oh, date, it's 24th. I have explained to him he has an absolute right to that exam. I believe the people have agreed not to habitualize this matter. 24th.
Sir, you're waiving your right to preliminary examination? Mr. Gerard, you're waiving your right to a preliminary examination?
Yeah.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes.
You understand that you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yes, Your
Okay.
Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 following.
When a defendant waives preliminary examination, they're skipping the probable cause hearing and allowing the case to move directly to circuit court. Why waive? Strategy. Sometimes the defense doesn't want testimony locked in early. Sometimes a plea deal is in motion. Sometimes evidence is overwhelming. The preliminary exam is where the prosecution must show probable cause. Waiving it removes that step entirely. This is not surrender. It's often tactical.
Your Honor, we'd waive reading, stand mute, ask the court to enter a not guilty plea.
Defendant having waived formal reading, standing mute to both counts, court will enter a not guilty plea. Pretrial will be set for May 5th, 2025, 1:30, Judge Hamud.
Your Honor, I believe he has other matters set with Judge Hamud on the 12th. I don't know. Well, they'll just move him if he does. Thank you.
You're informing me of that because of why? You want me to give you the 12th?
I hate dead air.
What?
I hate dead air. No, the 5th is fine, Judge.
Okay, good. Thank you. Fine, continue. I cannot figure everything out. Court does call the case, People versus Gervais Drake.
And then we have people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Drake, who approaches, Your Honor.
Your name? Gervais Drake.
Your Honor, we're just asking to set for exam at this time.
Discovery is complete.
To my knowledge, yes.
People have their witnesses available to 6.
We'll do our best, Your Honor.
Preliminary examination in person. May 6, 2025, 12 noon. That's before me.
Thank you, Your Honor.
Thank you. Bond continued. Court does call the case People versus Haley Gregg.
Jennifer Douglas for the people.
Oh, she was still here. I
I'm
told you.
back. Couldn't get rid of me that easy. Christina Costantino appearing on behalf of Haley Gregg.
Your
Miss-
name?
Haley Gregg.
Here.
Judge, this is the date and time set for PCC. I was just appointed quite literally about 10 minutes ago. So given that, I would be asking for an adjournment of the PCC.
Is this the only thing holding her?
No, you're.
All right.
Judge, it was my understanding that her only other hold was a Melvindale misdemeanor warrant, and Melvindale has indicated that they would not pick up on that warrant.
Well, I'm just looking, do you want 12 days out or you want 1 week? Because she's in custody. So I can do the 1st or the 6th.
Unfortunately, Judge, I'm in trial next Thursday, so I can't do
Can't
next.
do the 1st, so I'll set it for the 6th for BCC. It's a Tuesday.
I have the 2,000 cash of surety bond on an RNO A and B case.
I thought you had you said you had
That's what he said. No,
After failure to appear.
All right, I'm just trying to give her the quickest date I can.
Understood, Judge.
So if you're not available the 1st, I'll do the 6th.
That would be great, Judge. Thank you.
May 6th, 2025. That's at 9 a.m. All right, for a probable cause. All right,
Thank you, Judge. I
thank you.
would also like to address bond. I know we've
She would.
touched on it a bit. It's my understanding her bond in this matter is 5,000 with a 10% bond. It's my understanding of the circuit court matter that I think the people were mentioning a second ago. My client tells me she received a personal bond on that file at her last court date. She is 34 years old. She does have employment lined up should she be released. She would be working at a medicinal cannabis retail store. She would.
Okay. Now go ahead. It's like,
She does.
like she has a job at a liquor store. Go ahead. No, I'm kidding. Go ahead.
Very important jobs. It's a very important sector of our economy. She does have housing lined up as well.
Wow.
She would
You're
be.
vouching for that.
She would be.
Yeah.
She would be able to reside in the city of Ypsilanti with a friend. She also is on the housing list through Avalon Housing. She would be working with CMH. She, previous to her incarceration, was working with CMH and attended therapy at least 2 times a month. It's my understanding that the other holds out of Wayne, as mentioned, they would not pick up on. We'd ask the court to consider a personal bond. If the court is unwilling to do so, we would also ask if the court would consider release to treatment. She has indicated that she does think treatment would be appropriate for her at this time.
Kind of treatment.
Substance abuse treatment.
Cannabis store. No, I'm kidding. Go ahead.
Your Honor, at this time, we believe that her bond is appropriate. She does have multiple other matters pending. We would point out that the date of extension of this case is the day after she was released on another case. I don't know if you remember Ms. Gregg from last time she was here. But Your Honor, given that she picked up this case.
Because she had to get away from here after she was released. So she just grabbed a car. Whose car did she grab? Allegedly.
Allegedly, Judge.
Allegedly, it was a police car.
No, what?
Okay, never mind. My bad.
No.
She just took a car because she had to go. Allegedly.
Allegedly, Judge.
And she's already had a failure to appear on the RNO case back in February. So we don't think that a reduction in bonds.
If I may, Judge.
Go ahead.
Judge, my only response to that would be treatment, I think would be perhaps a great middle ground for her. She's indicated a willingness and a desire to obtain treatment. Certainly, I think with treatment there, the risk of failure to appear is significantly diminished.
If you prepare an order, I'll release her on a PR to treatment.
Thank you very much, Judge.
Your Honor, could there be a tether, to keep her in inpatient treatment at that place?
Well, I'm not running. I don't know that she's gonna need a tether. I mean, if she goes into treatment. No, I'm not gonna do a tether on her. I'll just indicate that she can be released to treatment on a PR.
Thank you, Judge.
At this point, however, her bond will continue.
Thank you.
Court does call the case of the People versus Muhammad Farah.
Ready, Judge.
Andrew Childs, appearing on behalf of the people.
Court shall fix the first assistant public defender on behalf of Mr. Muhammad Farha. Please state your name for the record, sir.
Mohammed Farha.
Thank you, Judge. We are still in the process of trying to get this matter resolved. We are requesting a brief adjournment so he can provide proof of his treatment to the prosecutor's office, and we can hopefully find a resolution, Your Honor. He is in compliance as far as I can tell now. Last time we were here, you had him go drop, and he dropped and came back clean, Your Honor.
I have proof of treatment with me right now.
Okay, well, he's gonna need time to review it.
Okay.
So you're looking for how much time?
Just a couple weeks, Judge.
Probable cause conference in this case will be adjourned May 6, 2025, 9 a.m.
Thank you, Judge. I'll provide that proof to Mr. Childers and try to get this matter resolved on that time.
All right. Thank you, Mr. Clark.
Yes, everything is still in place.
Okay.
Keep doing it. Thank you, Judge.
Court calls the case People versus Antonio Jackson.
Alexander, on behalf of the people, Your Honor.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Jackson. Please state your name for the record.
Antonio Jackson Jr.
Thank you.
Your Honor, we're asking that this matter be set for a preliminary exam.
Your Honor, if I could address bond appropriate.
All right. Discovery is complete.
To our knowledge, yes, Judge.
People have their witnesses available to
We'll do our best.
She's up.
set preliminary examination in person, May 6, 2025,
9 a.m. before the hearing.
9 a.m. before Judge Perry. Yes, as found.
Your Honor, I do want to make the court aware, in checking the defendant's jail calls, he has tried to contact the victim 33 times since arraignment. She's not picked up the phone, but he has been trying to call her 30 times.
Any response?
No, Judge.
33 attempts to contact a victim after arraignment is serious. Even if calls weren't answered, attempted contact can violate bond conditions. Bond conditions typically prohibit direct or indirect contact. Courts take that extremely seriously because victim protection is paramount. Notice how the defense offers no response here. Silence can signal limited defense. When judges revoke phone privileges, it's preventative, not punitive. It's about stopping potential harassment or intimidation before escalation.
Defendant's phone privileges at this time are revoked. Found otherwise will continue. Thank you. Yes, to the extent it's true. After the second time, why are you calling back? Never mind. Court calls the case. People versus Durantu Francis. That's Suzanne.
Good morning, Your Honor. Assistant Public Defender Tanazi Carey on behalf of Mr. Durantu Francis. Ms. Francis, state your name for the record, please.
To Francis.
Thank you.
The court should have a green sheet.
I do.
I think we did receive an offer today. We just need to relay it to Ms. Francis, and I think 2 weeks should be fine, Judge.
Probable cause conference, May 22nd, 2025, 9 a.m.
Thank you, Your
On
Honor.
continue. All right, thank you, ma'am. Cross case people versus Sean Johnson.
And is that on behalf of people, Your Honor?
Mike Gaddy, Assistant Public Defender, Mr. Johnson. He's in lockup too. He's making his way to the.
What? I'm sorry. You're there. Johnson.
Your Honor,
State your name, sir.
Sean Michael Johnson.
Thank you. What are we doing?
Your Honor, we're asking you to set this for a preliminary exam.
Discovery is complete.
Your Honor, I have spoken with Ms. Zenda. There was some video. She says it's on our way to our office, so I'm confident.
And that's correct, right? There's a meeting, so it should be here by Monday. And if people could address bond when appropriate.
Preliminary examination in person will be set May 6, 2025. Huh?
Yeah.
It's at 12 noon before me. That's the bond.
Your Honor, this defendant has tried to contact the victim 29 times since arraignment with one completed call. And in this call, he talks to their child, who then passes the phone to the victim. And in that call, he asks the victim for money to put on his account and also tells her, you know, I'm going to prison, right? So I'm concerned that his phone privileges be revoked. We'll be asking the jail to block that number.
Your Honor, I was made aware of this earlier this morning. I haven't had a chance to look into it. I guess I'd ask the court as an interim provision to block that number, the number of the alleged contacts, and not revoke the privileges. I believe the bond is currently set at $25,000, if I'm not mistaken.
If bond will continue, defendant's phone privileges are revoked. You can raise it if you find out something different at the time of his preliminary examination, but at this time they're revoked.
Thank you.
Phone privileges revoked. Bond continues. This is a strong judicial line. Even without a full evidentiary hearing, the pattern of attempted contact justifies restriction. It sends a message. Bond is freedom with boundaries. Cross those boundaries and privileges shrink. Judges rarely hesitate when victim safety is implicated. More coming next.
Court does call the case. People versus Lena Harbali.
For people. Your Honor.
Okay.
Mike Gaddy, Assistant Public Defender for Ms. Harbali, who's here to my right. State your name, ma'am.
Lena Harbali.
Thank you.
Thank you. Your Honor, we are requesting an adjournment for this matter. We actually did submit a Zoom request, but Ms. Harbali was released from the hospital in time to be here today.
Okay.
So we are endeavoring to go to mental health treatment court. I have reached out to Mr. Graveline. I haven't heard back. Oh,
No, go ahead.
whenever someone does something, I always think it's me.
No.
We are trying to get screened for mental health court. There was a delay
Got it.
based on.
Okay, no, that's fine. Probable cause conference, May 22nd, 2025, 9 a.m. All right, bond will continue.
Thank you, Judge. It's right on the phone.
Your Honor.
Thank you. Court calls the case. People versus Anderson Keller.
Good morning, Assistant Public Defender Davi Lebo, on behalf of Mr. Keller, who's approaching from my right. Mr. Keller, could you please state your name, sir?
Anderson Christopher Keller.
Okay, what are we doing?
Your Honor, we're here today for a competency hearing as well as a probable cause conference. I have received the competency report from the Center for Forensic Psychiatry and would be prepared to stipulate the results finding Mr. Keller competent.
Are you talking about the March 13th report?
Your Honor, I can double check the date on it, but I believe so. Actually, yes.
Are the people in receipt of that report?
Yes, Your Honor.
All right.
We would also stipulate we have no further reference.
Based upon that report, the court would find that the defendant is competent. Right.
Your Honor, with regard to the
report specifically would indicate that the defendant can understand the nature and object against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. Do you have an order?
No, Your Honor, I can prepare one.
Okay. All right, what are we doing?
Your Honor, with regard to the PCC, would like to set this matter for preliminary examination, please.
You have all the discovery.
Yes, Your Honor.
We'll be able to have their witnesses available to 6.
I don't know, Your Honor. I'll try for that date.
All right. Preliminary examination will be set May 6, 2025. 9 a.m. before Judge Perry.
Thank you, Your Honor.
Courthouse case People versus Brian Howell.
Ashley Money for the people.
Your Honor, Constable Bass on behalf of Mr. Brian Howell, who is present to my right. Mr. Howell, can you state your full name for the record, please?
Good morning, I'm Brian Howell.
I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates that he's going to plead to use of a controlled substance to 1-year misdemeanor. Upon a successful guilty plea to that charge, count 1 would be dismissed. Well, hold on a second. He's also going to plead to counts 2 and 3 as charged.
That's correct, Your Honor.
So he's pleading to counts 2, 3, and 4.
Yes, Your Honor.
Correct, Your Honor.
And then, okay, and then count 1 is dismissed. Is that, that's the court's full understanding?
Yes, that's correct, Your Honor. And my client is looking to get into the drug treatment court over in Oakland County. He has spoken with them over there, but it's pending this plea so that we have to get this done.
So with this plea, he'll be able to get in?
Correct.
Okay. All right. I know we've been trying to do that a minute. May I have him sworn?
Brian, do you solemnly swear and affirm the testimony you're about to give? Do you solemnly swear and affirm the testimony you're about to give with the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Brian Howell.
All right. Sir, it is this court's understanding that you're going to plead guilty to 3 misdemeanors. Is that correct?
Yes, Your Honor.
All right. First of all, that you're going to plead guilty to the stated count 2 of operating with your license suspended, denied, and or revoked. That's a misdemeanor punishable by up to 93 days, $500 fine plus court cost. Vehicle could be subject to mobilization. Understand that?
Yes, Your Honor.
Count 3 also that you're going to be pleading guilty to is the charge of open intoxicants in a motor vehicle. That's a misdemeanor punishable by up to 90 days, $100 fine plus court cost, community service, and any substance abuse treatment. You understand that?
Yes, Your Honor.
And then also that you'd be pleading to the charge of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court cost. You understand all of that?
Yes, Your Honor.
All right. And you understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court.
Yes, Your Honor.
Understanding that you still wish to plead guilty to these charges?
Yes, Your Honor.
To the charge of driving while license suspended, denied, and or revoked, how do you plead?
Guilty.
To the charge of open intoxicants in a motor vehicle, how do you plead?
Guilty.
To the charge of use of a controlled substance, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form?
Yes, Your Honor, it's here.
You signed an advice of rights form?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yes, Your Honor.
Were you on probation or parole at this time of these offenses?
Yes, Your Honor.
All right. Then I need you to understand your plea in this case could be a violation of that probation. And you need to understand that as such, that other court could sentence you to the maximum allowable under those other charges. You understand that?
Yes, Your Honor.
And understanding that, do you still wish to plead guilty to these charges?
Yes, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will,
Yes, Your Honor.
and because you believe that you're guilty of these offenses?
Yes, Your Honor.
March 17, 2024, at the location of M52 near Newkirk Road, Manchester Township, Washtenaw County, State of Michigan. Were you operating a motor vehicle?
Yes, Your Honor.
At the time, was your driver's license suspended, denied, and or revoked?
Yes, Your Honor.
And did you know that it was?
Yes, Your Honor.
All right. And while you were operating that motor vehicle, did you have open intoxicants in the motor vehicle?
Yes, Your Honor.
What'd you have?
I had an open cowboy, which is open beer.
Really? Like I didn't know, because I just crawled from under a rock. I get you. You had an open beer in the vehicle, right?
Yes, Your Honor.
Okay. And you knew it was there?
Yes, Your Honor.
All right, and it was yours?
Yes, Your Honor.
All right. And had you used a controlled substance on that day?
Yes, Your Honor.
What?
Adderall.
All right. Did you have a prescription for it?
No, Your Honor.
All right. And you knew what you were using was Adderall?
Yes, Your Honor.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is also satisfied, Your Honor. Thank you.
Court will accept the defendant's pleas of guilty to counts 2, 3, and 4. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14 and 4 probation. Sentencing will be June 10th, 2025, 9 a.m. before Judge Fresh Hour. And on this will continue. Mr. Howell, good luck to you, sir.
Thank you, Your Honor. It's been a pleasure.
Thank you.
Court does call the case of People versus Michael McLean.
And then on behalf of the people, Your Honor.
Basically, on behalf of Mr. Michael McLean, who is present to my right, you state your full name for the record, Michael.
Michael James McLean.
Thank you.
Your Honor, today is the date and time set for a probable cause conference. At this time, we'd be respectfully requesting to set this for a final settle. I'm sorry, not final settlement, preliminary exam.
And your people can address bond.
Yeah, of course. Hang on. Would people have their witnesses available on the 6th? Preliminary examination in person, May 6th, 2025. 9 a.m. Is it 12? 12 noon. That's before me. Yes, that's the bond.
When it's come to my attention, he has made 127 attempted calls to the victim since arraignment was 2 completed on 4/16 and 4/8.
How many?
127 attempted calls, 2 were completed.
127 attempted calls. Let that sink in. That's no longer misunderstanding. That's persistence. From a legal standpoint, this is devastating for bond credibility. Bond conditions typically prohibit any direct or indirect contact with alleged victims. Attempted contact, even unanswered, can qualify as a violation because it demonstrates intent. The prosecution highlights the volume deliberately. 2 completed calls out of 127 attempts reinforces pattern behavior. Judges look at patterns, not isolated incidents. This also impacts sentencing perception down the line. Judges remember post-arraignment conduct. Compliance during bond is often seen as a preview of future behavior. This is why phone privileges are revoked immediately. It's protective and preventative, not reactive punishment. And here's the broader question. At what point does attempted contact become harassment in the court's eyes? For many judges, 127 attempts is well past that line.
So I'd be asking that his phone privilege be revoked.
Oh. Response?
No comment at this time, Your Honor.
His bond will continue. His phone privileges are hereby ordered revoked.
Thank you, Your Honor.
Calls the case, People versus Zakaria Haruska Dennis.
Rachel McDuffie for the people.
What?
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Haruska Dennis.
No, wrong. Doesn't matter, he's not here.
Just for the record, I'd ask for an adjournment. He did reach out earlier this week and left a voicemail. I attempted to reach out and follow back up. We are missing some outstanding discovery, but I don't have an answer for his non-appearance today.
Bench warrant will issue. Bond 10,000. Cash surety, that warrant will issue immediately for Mr.
Failure to appear. No explanation. Bench warrant issued immediately. This is the fastest way to lose judicial trust. When a defendant does not appear and counsel cannot provide a verified reason, the court must act to preserve authority. A $10,000 cash bond, not 10%, not personal recognizance, signals elevated concern. Cash bond requires full payment up front. It's the court saying your reliability is now in question. Notice how there's no prolonged debate. Non-appearance changes everything. Courts cannot function if attendance becomes optional. In criminal procedure, appearance is foundational. Without it, the system collapses. That's why this response is swift and firm.
No. I'm telling you. Court calls the case People versus Robert Mitchell.
Bashir with him on behalf of Robert Mitchell.
Robert Mitchell.
Thank you, sir.
To our knowledge, discovery is complete and we request the earliest possible exam date that the people can accommodate.
People, other witnesses available to 6.
We'll try, Your Honor.
Preliminary examination in person, May 6, 2025, 9 a.m. Is it 9?
Yes.
Before Judge Perry.
Thank you, Your Honor.
Thank you,
Thank you.
Bond. Thank you. Thank you. Court calls the case People versus Anthony Johnson.
Ally's in on behalf of the people, Your Honor.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Johnson, who appears to my right. Mr. Johnson, can you put your name on record?
Anthony James Johnson.
Your Honor, we submitted a waiver request on this.
All right. Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand that you won't have that proceeding and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendants found over to circuit court on counts 1 and 2 with 3 following.
Acknowledge receipt of information, Your Honor. Wait formal reading, stand mute at this time.
Defendant have a waive formal reading, standing mute to all counts. Court will enter not guilty plea. Pre-trial will be set for
June 17th, 1:30 before Judge Comfy.
June 17, 2025, 1:30, Judge Comfy.
And Your Honor, we can address bond briefly.
Okay.
That's far out.
It has come to my attention from the victim, she sent us a screenshot that the defendant has sent her a Facebook request, friend request. So I'm concerned he's trying to reach out and contact her.
Your Honor, in talking to my client, we have decided to address this issue head on. My client has an explanation for this that he would like to offer to the court.
Go ahead. Is he admitting to that?
Yes, sir.
Mr. Allen?
He is admitting to that, Your Honor. The explanation is. You want me to?
I can say it.
Okay.
It was a mistake. I was pushing remove and push add friend. That was simple. That's what I did.
This is one of the more nuanced bond violation explanations we've seen today. The defendant admits sending a Facebook friend request to the alleged victim, but claims it was accidental. Big thumbs, wrong button, immediate removal. The problem isn't just the click, it's the condition. Bond conditions typically prohibit direct or indirect contact through social media. That includes friend requests. Even if accidental, the act technically violates the condition. The prosecution adds another layer. The account was allegedly newly created and not under her name. That raises suspicion about how he identified it. The defense argues lack of intent. But bond violations don't always require malicious intent. Sometimes mere action is enough. The judge reads the condition aloud. That's deliberate. It reinforces clarity. And then the ruling, bond revoked. This demonstrates something important. Courts often treat digital contact just as seriously as physical contact.
Your Honor, he tried to eliminate the possibility of any contact. He saw that she popped up. He wanted to remove any possibility that he could have contact with her. That was his intentions. And
how did that even happen though?
Just,
I mean,
done.
Okay.
big thumbs, Your Honor.
I was a mistake, sir. I admit it though.
He didn't intend to contact her. There's no allegation that he actually made contact with her. Like I said, he wanted to eliminate the possibility of that. He made a mistake.
Nope.
Hold on.
In reporting the violation to us, I believe she told us that she had made an entirely new Facebook account, not using her name, and that was the account that sent a friend request to. She wasn't sure how he found that account, but he added her as a friend and she needs to report it.
Your Honor, the only thing I can provide is that when new accounts pop up, the suggested friends that pop up, he likely noticed that it was probably hers. He intended to remove it to eliminate any possibility of contact. He immediately, when he clicked add, he immediately went back and clicked remove. Realizing the mistake, he blocked her. Again, there's no allegation that he actually had contact with her. He doesn't want contact with her. He understands that he's on bond and he doesn't want to do anything to lose that. And
do not have or attempt to have direct or indirect contact with the above individual in person or through others by electronic communication, including but not limited to phone, email, texting, internet, or social media.
Well, Your Honor, if it was not under her name, I don't know how he could possibly have also known that it was her definitively.
Then why would he have attempted to remove it?
Because the possibility that it could have been, I imagine. He advises that it was her face. So he wanted to.
He knew.
Well, Your Honor, he is just providing an explanation as to why he wanted to eliminate the possibility of contact. It did pop up. He did remove it. He's asking that the court. He blocked her. He is asking that the court take that into consideration. He's asking, we are pleading with the court to allow him to remain out on bond at this time. And he was, for what it's worth, honest with the court about that. He is taking accountability for it.
Anything else? Tell you not to have contact. He sees her face. He attempts to make contact with her. He can't violate the bond that way. Just plain and simple. Defendant's bonds revoked. Defendant's remain. Court calls case, People versus Bruce Pickens.
Stephanie Can on behalf of Mr. Pickens, who is appearing to my right. Mr. Pickens, could you please state your name for the record?
Bruce Pickens.
Your Honor, you should have a green sheet in your possession. I'm simply asking for a 2-week adjournment. A name request has been done for my client to see if we can get some mitigation.
Said 2 weeks?
Yes, sir.
I need 12 days, so I'll set probable cause conference in these matters will be May 6, 2025, 9 a.m.
Now we shift to mitigation and mental health considerations. In this segment, defense counsel is actively seeking treatment screening and mitigation efforts before resolution. Mental health court and diversion programs represent a different philosophy of justice, problem-solving courts rather than purely punitive courts. When defense attorneys request adjournments for screening, it signals strategic rehabilitation positioning. If a defendant qualifies for specialty court, outcomes can shift dramatically. Structured treatment instead of incarceration. Judges often accommodate these requests because long-term compliance reduces recidivism more effectively than short-term detention. This is the system functioning not just to punish, but to redirect.
Also see you before then, and you'll hear from our staff to try and get you some mental health and also start working on a home.
Bond will continue. Thank you.
Thank you.
Case, People versus Marcus Jones.
Hey, Judge.
Hey, how you doing? I'm doing.
Worship Feaster, First Assistant Public Defender on behalf of Mr. Marcus Jones. Mr. Jones, please state your name for the record.
Marcus Jones. Thank you, sir.
People. Thank you, Judge. I think we were here a couple weeks ago, which time Mr. Jones was in treatment. He is now out of inpatient treatment out of the hospital, but he's going to be going back into a outpatient.
Patient
Yes.
program.
So, my understanding is, once he completes that, that might have an impact on the resolution in this case. So I'd ask for, 3 or 4 weeks or more adjournment so we can get him going.
If I may, Your Honor, I did attempt to do, I'm sorry, I did set an appointment for myself, but I missed it, so I had to reschedule another appointment. So I was planning on scheduling another appointment, after court today.
Today, okay, all right, real good. Let's do this then. Let's see how you're doing through the program and everything. I'll adjourn it out to May 29th.
Okay.
Okay. Thank you.
Okay, you're welcome. 2025, 9 a.m. Okay, you take care of yourself, young man.
Why
Got something right
Yeah,
here.
I'm making a hallway. Okay. Thank you, Judge.
Court calls case, People versus Scott Reese.
That's a lot of people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Reese. Please state your name for the record.
Scott Reese.
I think we're gonna be filing a no cross in this case.
Any objection?
No objection.
Case is dismissed.
Missed all 3 counts.
Okay, thank you.
You're welcome.
Thank you, sir.
Today's courtroom session under Judge Simpson illustrates the full spectrum of criminal procedure in action. Guilty pleas carefully taken. Bench warrants issued without hesitation. Bonds reduced when trust is earned, revoked when violated. Victim protection prioritized. Digital conduct treated as real-world contact. We saw defendants navigating probation risks, treatment opportunities, specialty courts, and the consequences of repeated noncompliance. The legal system here is not random. It is structured discretion. Judges rely on patterns, credibility, and procedural safeguards. Every advisement, every question, every clarification protects the integrity of the record. Some walked out on personal bonds. Some lost privileges. One had charges dismissed. One lost bond entirely. That's the unpredictability and precision of courtroom reality. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.